Public Law Center, OC Resilience, Orange County Justice Fund, Santa Ana Unified School District, Latino Health Access, and the Harbor Institute of OC. I will now give Supervisor Sarmiento the mic for his remarks. Supervisor?
Gracias, Martín, y buenas tardes. Sin Chauquidi. Good evening, everybody. I am so happy to be here with you, and I want to welcome you to tonight's Immigration Rights Community Forum. First of all, let me just begin by thanking those who made this possible. Many in my staff here who, this is the first time for us hosting a virtual town hall community forum, and the technical challenges, the work that leads into this is not anything that's easy. But I do want to give a shout out especially to our friend Evelyn Benitez from Santa Ana Unified School District, who does this often. School districts tend to do things better than other government agencies. So thank you, Evelyn. Thank you to all the participants, the lawyers who are here, the partners who are here, and my fellow colleagues who are elected officials both at the city level, at the school board level, and at the legislative and congressional level. So thank you all for partnering with us tonight. And simply what I wanted to impart with all of you is we are going to be translating this into Vietnamese and Spanish, so I'll be speaking in English so we can cover all three. Really, this is an opportunity and a forum for us to try to share information from professionals that can provide you with the most accurate, the most reliable information when it comes to immigration law, your due process rights, and really protections that we have in place. We are blessed to live in a beautiful county where we have people that know the value of the immigrant community and know what we all stand for, which is hardworking people who've come to this country like everybody to make sure that we create a safe space. We live in a state that has had some ordinances adopted, laws adopted that will make sure that we protect our immigrant families. So we know there is a lot of fear and confusion, but I don't want us to lose hope. I don't want us to feel like we're alone. And that's what tonight's forum is all about, is to make sure you all know that you're supported not only by your elected officials, but you're supported by a network of nonprofit organizations that have dedicated their time and their life to making sure that they represent all of us, especially the immigrant population that tends to be, unfortunately victimized, scapegoated, and really, distorted because we know that as an immigrant myself, we all come to this country to contribute, to support, to create a better life for our families. And that's really the narrative that we should be sharing rather than one of fear. I want to tell you, I'm so inspired by the students I see that are marching, protesting, talking about who their parents are and who their families are. Those are invaluable. Those narratives are invaluable for us to make sure that we continue to uphold. But we know that this fear doesn't come at a small cost. We know that kids aren't going to school, parents aren't going to work, some people aren't receiving their health care, so there is a tangible cost to very, very dangerous language. So I want us to overcome that and let you know that here in California, we have something called SB 54, the Values Act. And that's something that was adopted in 2018. And in essence, it basically says that no state or local resources are going to be used to assist federal immigration enforcement in our schools, our hospitals, or our courthouses. Nobody cannot ask for your immigration status, and you cannot be arrested for a simple deportation order. Now, that doesn't mean that we're going to be harboring people who commit crimes, commit violent offenses. We all agree that people who commit those offenses should be detained, should be arrested, irrespective of immigration status. But we want to make sure that people understand that simply for being a status offender is not a reason for us to be mass deporting families that have been here for years and are working and contributing to our tax base. I was really encouraged when I saw comments from Orange County Sheriff Barnes, where he said securing the border and enforcing immigration law are responsibilities of the federal government. They do not and never will ask immigration status of victims, witnesses, suspects, and those who call to report crimes. That's encouraging. That's something that we know We want to make sure people continue to call out crimes. If they're victims of crimes, for them to come forward. If they're witnessing crimes, we want them to come forward. That's something that we certainly support. Police Chief Robert Rodriguez from Santa Ana said that they will not participate in any immigration enforcement activities, including operations by Federal Immigration and Customs Enforcement Agency. He's a former undocumented person himself. He said that his mission is centered around public safety and not immigration enforcement. And this erodes the public trust if we start seeing local agencies doing, federal enforcement. That's not the function of a federal law enforcement agency. And recently, we know that the Santa Ana Unified School District passed a policy to make sure that they treat all students equitably, that they make sure that free and reduced lunches are extended to all students, all families, and transportation and educational instruction as well. As a former mayor of Santa Ana and a former council member in 2016, one of the proudest things I did was to help Santa Ana become a sanctuary city. And what I do want to make sure everybody understands is simply what it means to be a sanctuary city is that we're going to protect sensitive information of our residents. We're going to prevent bias-based policing, making sure that police cannot help identify, investigate, arrest, or detain any person solely on the basis of a suspected violation of immigration law. That is very different than a criminal penal violation. If somebody violates, once again, the law and commits a crime, that is something that is punishable. That is something that must be prosecuted. We know that people prey upon the immigrant community probably more so than the mainstream community. So we want to make sure that we keep our community safe. So, I am just very hopeful and optimistic about where we are. We've been down this path before. We've seen this movie before, and we've gotten through it. And I know we're going to get through it again because we have some very committed partners. We have a judiciary that I know is going to hold strong. But more importantly, we have a resilient community. We have a strong community that is never going to let inflictions of harm happen unaddressed. And so that is what tonight is about, to let everybody know that we are not alone as a community. We are going to continue to fight shoulder to shoulder against things that oppress us and harm our families and our community. So with that, I'm going to turn it back over just to Martin so he can recognize our next speaker. But again, from all of us here in the Second District, especially my office and everybody who contributed to this, I just want to thank you. Que Dios los bendiga. God bless you. We're going to be fine. Let's be hopeful. Let's be strong. Let's be resilient. And let's learn a lot of good information tonight. Thank you, everybody.
Thank you, Supervisor Sarmiento. I will now like to introduce the Mexican Consul General in Santa Ana, Audrey Rivera Gómez. Consul, buenas tardes.
Buenas tardes. Muchas gracias por este espacio tan importante en estos días. Dirigir este extraordinario foro Conoce y ejerce tus derechos a toda nuestra comunidad. Sin lugar a dudas, es una gran iniciativa y a nombre del Consulado de México, nuestro reconocimiento al señor Supervisor Vicente Sarmiento por esta iniciativa, por su trabajo arduo en beneficio de nuestra comunidad en la protección de sus derechos. El Consulado de México aquí en Santa Ana tiene y cuenta con un programa de asesorías legales externas. Es un programa por sus iniciales en español, PALE, que está a disposición de todos los mexicanos. Es un programa con este tipo de asesorías. Lo forman abogados especialistas en materia de migración, laboral, civil, administrativo, penal y, como dije, está a disposición de los ciudadanos mexicanos. Es totalmente gratis y está en el consulado permanentemente, pero además también este programa, como decía, está formado por especialistas y también durante los consulados móviles se ofrece también este tipo de asesorías y acompañamiento en los diferentes casos que se lleguen a presentar. Por otro lado, también contamos con el Centro de Información y Asistencia a Personas Mexicanas, CIAM, por sus siglas en español, que está a disposición 24 horas, 7 días a la semana. Y como ustedes podrán observar, también se dan las asesorías y orientación integral, asesoría en materia jurídica y migratoria, y es para todo Estados Unidos y Canadá. Es decir, el lugar donde se encuentren, ustedes pueden contactar a ese número de teléfono que ustedes pueden ver en su pantalla, 520-623-7874. Como dije, es permanente, 24 horas, 7 días a la semana. Y el programa PALE, también dirigido a personas mexicanas en el exterior. Y por supuesto, nosotros también tenemos el apoyo además de la red consular, es decir, como bien decía el supervisor, no están solos, todos estamos uniendo esfuerzos para proteger y sobre todo fortalecerlos. Así que lo único que tienen que hacer es estar en contacto, actualizarse en la información, estar bien informados, y este foro también es un gran paso que se da en esa dirección. Ahora, el teléfono de protección también se los comparto, el 714-504-2796. Ese teléfono también está disponible 24 horas, 7 días de la semana. Para ya no profundizar más y darles también la palabra a los abogados para que puedan contestar las preguntas que tengan, las consultas también. Entonces, hasta aquí dejo mi intervención. Muchas gracias por la atención y por la invitación. Gracias.
Thank you. Gracias, Consul Audrey Rivera Gomez. Before I introduce my next guest, I want to thank Garden Grove trustee Walter Muneton for his support. And also for those who just joined us, I will mention that we have translation available in Spanish and Vietnamese. You can find a globe icon at the bottom of the screen and select your language of choice. You will need to mute the original audio using the button that appears on your screen once you enter the translation room. That way you are not hearing two speakers at the same time. Thank you. I will repeat that in a little while. Now let me introduce our panel of attorneys that will be presenting and responding to questions at the end of the presentation. With us, we have Jose Alfredo Hernandez, an immigration attorney based here in Santa Ana. Gloria Martinez, an immigration attorney with Community Legal Aid, SoCal. Jacqueline Dan, an attorney with expertise in criminal-related immigration issues with the Orange County Public Defender's Office. We're going to start with attorney Jose Alfredo Hernandez.
Okay. Thank you, Martín. Muchas gracias a todos. Nomás les quiero informar que vamos a hablar en inglés ahorita, pero tienen traducción disponible si apresuran el botón que está indicado en su pantalla. Good evening, everyone. My name is Jose Alfredo Hernandez. I'm an immigration and criminal defense attorney that I have been practicing here in Orange County for the past 24 years. I want to begin by letting you know that I, too, was an undocumented individual. I lived here for about 10 years before being able to regularize and take advantage of the legalization called amnesty back in the 1980s. I think it's important for all of us to understand that this isn't a new dilemma that we're facing. We have been dealing with these types of issues for several years, and it's just simply a different wave. I think it's important for everyone to recognize that it's important to remain calm. It's important to understand what is happening, and we're trying to give you a small preview of what your rights are. Again, this form is very limited, but we will have an opportunity to provide you with more information, and certainly myself and I know the rest of the panelists will make themselves available to all of you should you have any questions. But thank you very much for joining us. I'm going to begin with what we have described as individual rights. And so these individual rights are what really happens if you are stopped or detained by either immigration, customs enforcement, or customs and border protection, okay? It is imperative that you understand your rights, because by understanding them, you will know what to exercise. And you all have probably heard this before, but the very first right that we need to exercise is the right to remain silent. Aside from providing your name, you have no obligation to provide your immigration status, You have no obligation to provide your birthplace or how you entered the country. When officers make contact with you, they could either come to work, they could either come to where you live, and oftentimes they will encounter people when they're trying to enforce other arrest, warrants. So please understand that you have the right to remain silent. Please exercise that right. You also have a right to an attorney. However, given that this is a civil proceeding, you do not have a right to have an attorney provided to you. So an attorney that of your choosing would be the best person suited to represent you. I would probably implore any of you to kind of make a small list of people that you might want to reach out to. You might want to have a consultation with an attorney so you can understand your own personal, individualized situation. And if you do that, I would have a plan at my home, understand, whether you tell friends or family who they need to contact in the event that you are detained. You have a right to refuse a search warrant. Oftentimes officers will come in, or I should say agents will come in and show you what is called an administrative warrant. Administrative warrants typically have, it's not signed by a judge, I should say. It's basically signed by another special agent or an immigration officer, and they don't have the power to allow them to come in. For a warrant, you need to have it signed by a magistrate or by a judge. And if you don't have that, there is no right for them to come in, and you should not be opening the door. You can certainly ask these agents to show it through you through a window. You can ask these agents to show it through you by sneaking it under the door. But at no point in time should you be opening the door for these agents. And that applies whether you're at work, and that applies whether you're at home, okay? You do have a right to make a phone call. And again, this is what I'm talking about, being able to understand your own personal strategy. Who would you turn to should you have this type of encounter? I would suggest to you that you have somebody who you trust, somebody who can make additional phone calls, right? But I think that given that we're giving you this opportunity to get prepared, it is imperative that you all have a plan. You also have a right to refuse to sign any documents. Oftentimes officers, whether they do it intentionally or not, or at the direction of their supervisors, will present to you a document in which they tell you, look, you're signing your ability to go see a judge. And I think right now, one of those documents I have been able to put right in front of you, it's called the Notice of Rights. And when you see where it says request for disposition, there's three different, boxes that you can check off. Oftentimes they leave it blank and then they have the person sign. And the problem with that is that if you sign your right to away to see a judge, you will be given what's called the voluntary departure. And instead, what you need to exercise is your right to see a judge. Any individual that has been in the United States for more than 2 years has an absolute right to see a judge, right? And so it is imperative that you make that request. And so my recommendation to you is to not sign any kind of document unless you have been had a phone call with your attorney, or you might be able to see your attorney. At this point in time, I think it's imperative to let you know that once you are processed, you will be issued what's called an alien number. And that alien number is about 9 digits. That alien number is key to be able to locate you. So if your family members are trying to search for you and you have been arrested, the one thing that you will have plenty of time to do is to memorize that number. And once you do memorize that number and you make that call, that should be the first words out of your mouth to the person who you're contacting, whether it is a family member, a friend, coworker, or maybe even your lawyer. But that alien number is going to be key for us to be able to locate you. You have a right to a hearing, like I said, before an immigration judge when you've been here longer than 2 years. And oftentimes I tell people, begin to accumulate documents that are in excess of the last 10 years. Typically, individuals who have a parent, a spouse, or a child that is either a resident or a citizen gives themselves an opportunity to apply for certain forms of relief. Again, that conversation is beyond the scope of this presentation, but I think it's important for all of you to understand that gathering these documents is going to enable for anyone who's going to represent you to have an easier time to present the case. Once you are processed, one of two things can happen. You can either be released on your own recognizance, which it is my position or my belief that we might not see that too much with this administration. But the other thing is you have a right to request a bond hearing, right? So individuals that are not disqualified, meaning that they don't have an extensive criminal history or do not have prior orders of removal, can make this request before a judge. And once that request is done, you will have a hearing. With respect to the time, it typically should be done within 10 days. However, if they have an excess amount of people that are in custody, it's going to take anywhere from 20 to 30 days. I would urge you, all of you, to understand that you shouldn't be scared. I know that most of you have never gone through this process, but what you're doing is allowing yourself an opportunity to remain here and allowing someone to come in and help you so that you can remain here. Time and time again, over the past 24 years, I've seen plenty of people who have signed their rights away. And that is kind of a scary proposition because once you leave the country, then you're triggering all kinds of other consequences. But again, I can go into more detail should anyone have a question about that. You have a right to understand that you are not going to be mistreated, okay? And so if you are detained and one of these officers or agents are engaging in mistreatment, try to memorize that name, try to memorize the badge number if they show you one. But that is important for you to understand, okay? So what does happen when you are actually detained? Whether you're detained at the border, not at the border, I mean, but at the airport, or whether you're encountered here by ICE, typically they will try to question you. They'll be checking your immigration status. They'll be checking databases. Again, what they're looking for typically is, are these individuals, do they have a prior order of removal? Do these individuals have an extensive criminal history? So that's basically what they're going to be checking for. The next thing that they're going to do is probably conduct a medical exam. And in that medical exam, again, it is for the purpose of them being able to house you. Oftentimes officers, or I should say field officers, do not have the bed space locally. So do not be surprised if sometimes they move you out of state, whether it be Arizona, Texas, Washington. It is part of the typical process. Any attorney who handles immigration matters, though, can represent you throughout the United States. So that should not be a fear or a reason for you to sign your rights away. Over the past 24 years, we've represented people from New York City down to Miami and all the way in Seattle. Again, it is imperative that you don't sign your rights away. Okay. Once you are processed by an immigration judge, if the judge grants you bond, then your family will have to post that bond. Bonds in immigration are quite different than they are in the criminal setting. Bonds in immigration typically require for the full amount to be paid up front, whereas in a criminal proceeding, you typically are paying a percentage, whether it be 7, 8, or 10%, but that's not what happens in the immigration setting. So when I'm telling individuals and advising them on how to get prepared, not only am I telling them to accumulate documents to show their physical presence, I'm asking them to also organize their vital documents like birth certificate, marriage certificates of individuals with legal status in the United States, specifically their children, their spouses, or their parents. In addition to that, I would counsel you to probably begin to pitch in and do a little fund where you're going to be saving a little money, because the minimum bond that is requested is $1,500. But in this day and age, I have not seen bonds lower than $3,000. So it could be quite upsetting once you are issued a bond and you don't have the money to be able to provide it, okay? You will receive what's called the notice to appear. A notice to appear is a document that is referred to as a charging document. This is for individuals, again, that are not citizens of the United States. So whether you're undocumented or in certain circumstances, when you are a lawful permanent resident or a conditional resident, or you might have temporary protective status or even DACA status, those individuals are also subject to immigration laws. And if these individuals have broken the law, have a criminal record, they can and will be placed into removal proceedings. And both, whether you're undocumented or documented, you will be receiving what's called a notice to appear. And again, in that notice to appear, top right-hand corner, you will be seeing your alien number. And so if you hadn't seen it before, whether it's other paperwork or in a bracelet that they might put on you, it will certainly appear in the notice to appear, okay? Once you are placed in the immigration process and you go up before an immigration judge, the judge will give you an opportunity to have some time to hire an attorney. They will also give you a list of agencies or organizations that can provide some legal advice, either with a low cost or at no cost. But that's important for all of you to understand. And with that in mind, I know I have a limited amount of time, but I do want to touch on the fact that in our community, we tend to have what is referred to commonly as notario fraud. Please understand that here in the United States, if you're a licensed attorney, you are not typically a notary unless you go out of your way to get that license. Whereas in Latin America and Mexico, we typically have notarios who are also attorneys. And for our community members that are newer to the States, they sometimes forget or they don't understand that notarios are not attorneys here in the United States. Notario fraud typically gets people sometimes into a bit of trouble because they are not licensed to practice. They actually don't know what they're doing sometimes. Notarios, trust me, do have a purpose and a reason to exist. They are here to notarize important documents. They're here to provide you with general information, but they should not be exercising any legal work. But oftentimes we have had individuals that will file applications that people are typically not eligible for. Oftentimes we'll have our community members trying to obtain a work authorization. When they go to the notario, they'll actually fill out an application. The individual has no idea what they're signing. They're not being translated. And after they sign, and once the proceedings begin, they realize that they have just signed an application for asylum. For us Mexicanos, it's typically not possible for us to apply for asylum. And so that is something that all of you need to be very aware of. Oftentimes these notarios for this immigration process will charge excessive fees. And the reason they're doing that is because not only are they taking their own fee, but sometimes they hire attorneys who are willing to work with them, and they do it at a volume pace, meaning that they might charge you something that a typical attorney would not charge you in that fee, but they're doing it in order to forward them on to attorneys who are willing to do the work and have the notarios funneling cases to them. Okay. And the last thing that I get concerned about with notarios is they oftentimes miss deadline. Even those notarios that are trying to do good work, that they're trying to provide good information, again, they don't have the legal background, they don't have the legal knowledge of every proceeding available. And so over the past 24 years, I've had the unfortunate obligation to try to resolve some of the issues that have been created by notarios. And so it is imperative for all of you at this point in time that you understand the difference, and that if you're going to seek legal help, please make sure that you're getting the assistance from a licensed attorney. We have put up on the paperwork in your screen some of the information that you should be aware of. I'm hopeful that you guys are exercising that right to contact an attorney. I would urge you to figure out what your personal situation is so you can be better prepared for anything that does take place. And so with that, I think that it is important for all of you to understand that it is imperative to remain calm. It is imperative to know your rights. In the past couple of weeks, I have seen what the person who is described as the border czar basically stuttering on CNN and other news outlets, because he understands that when we have individuals that are knowledgeable, that are understanding their rights, they're going to have a very difficult time trying to enforce these orders that are being issued by an administration that is being reckless, in my opinion. So if we understand our rights, if we exercise our rights, we're going to be able to better protect ourselves. So I want to thank you for this opportunity to address you, and I'll be available to answer any of your questions. Gracias, Martín.
Thank you, Attorney Jose Alfredo Hernandez, for that important information. I can see there's a lot of more people joining us, so I will have another announcement en español. Las personas que quieran oír esta presentación en español, por favor, tienen que hacer lo siguiente. Abajo de su pantalla hay un pequeño globito o un mundo, miniatura. Lo que tienen que hacer es ahí apretar y seleccionar el idioma de su preferencia, y es muy importante también que apaguen el audio original para que no se confundan. Pero de cualquier manera, tenemos esta traducción disponible en español. Y vamos a seguir ahora con la abogada, Attorney Gloria Martinez, and your remarks.
Thank you, Martin. Hi, everyone. Gloria Martinez, Supervising Attorney with Community Legal Aid SoCal. So as Supervisor Sarmiento mentioned, one of the worries for our community is what to do if they're receiving public benefits for themselves, for their children. should they continue to receive those benefits. And so I wanted to provide just some vital information for you all regarding that. What's commonly referred to as public charge. So public charge is a test, an assessment that immigration usually makes when they're reviewing somebody's application for adjustment of status or green card. Currently, USCIS will take into account the applicant's age, their health, their income, and other factors to determine whether that applicant will likely become dependent or primarily dependent on the government for future financial assistance. Again, I do want to mention that this is an assessment that's done when somebody applies for their adjustment of status or their green card. I also do want to mention that it doesn't apply to all forms of immigration applications. And a lot of applicants that do apply for adjustment of status, depending on how they got their legal status, they are exempt from public charge. And so that includes those that have applied for asylum, those that have applied under VAWA, T visa, U visa, DACA recipients, TPS recipients, and if you're applying for citizenship. Those again are exempt from public charge, so USCIS will not even take into account that public charge assessment. The other thing to note is that immigration will only look at whether the qualifying applicant is the one that received financial assistance. So if your US citizen children are the ones that are receiving the benefit, that will not affect the applicant's public charge assessment. Immigration will also take into account if you filed an affidavit of a qualifying affidavit of financial support. So where you get a sponsor or joint sponsors to legally say that they will support you, financially support you so that you are not financially dependent on the government in the future. So that's key to prevent any negative public charge assessments. Another thing to note is that if you have received public benefits in the past, that does not necessarily mean that your application will be denied under the public charge assessment. In addition to that, not all public benefit programs affect the public charge. And this is the current policy now. We do anticipate that the Trump administration may make some changes to the public charge assessment, but this is how it currently stands. So immigration will only consider as part of the public charge test certain benefits or certain programs that were received directly by the person that is applying for the immigration benefit. Currently, those programs include cash assistance, including SSI, CalWORKS, COPY, general assistance, and also long-term institutionalized care, like being in a nursing home that's paid by Medi-Cal. So these are primarily the programs that are taken into that public charge assessment. All other programs may not be taken into account. And also, most undocumented immigrants don't even qualify for the benefits or the programs that are often considered in that public charge assessment. And again, as a reminder, if it's the applicant's family members, their US citizen kids, or US citizen resident parents that are receiving that benefit, them receiving that benefit will not affect the applicant, the undocumented applicant that is then applying for their green card or residency. Okay, so moving on, the next thing I wanted to kind of give information about is how you can start preparing yourself and your family members. One of the biggest questions that we're getting right now is, how do I prepare to take care of my kids if I am detained or if I am deported? And so we wanted to touch on some possible options. So the first option that people often take is asking a family member or a friend, a verbal agreement to take and watch over their children if they are detained or if they are deported outside the United States. One thing to note is that these formal agreements do not give legal authority for that person to make medical decisions or school-related decisions for their children. The police, schools, doctors, courts will not recognize that verbal agreement. So that's not often the best approach. The best approach, especially here in California, what's recognized is a caregiver's authorization affidavit. And I believe we'll be sharing a template of that affidavit that people can use. This affidavit allows that person to be able to make those school and medical decisions on behalf of the children. The benefit of this affidavit also is it's the caregiver or the proposed caregiver, the one that's going to be signing this affidavit. It's not signed by the parent. Another benefit is that it does not affect the parental rights. So it doesn't take away the parent's rights over those children. This document is a free document that you can also find on the internet. So that you don't have to pay for this document or this process, and it doesn't have to be notarized. So this is the recommended approach. If you want to ask somebody to be that proposed caregiver, and so in the moment that you are detained or you are deported, at that point is when the caregiver would sign that affidavit, giving them that legal authority over the children. Now, the other process is what's called a legal guardianship. Now, this is a process through the courts where the court would appoint a legal guardian over the children that would grant them full legal and physical custody to be able to make decisions on behalf of those children. However, one thing to note is that the guardianship process can often take a couple months, so it's not a fast process. The other thing is that once the guardianship is in place, the children will have to live with that guardian. It does not terminate parental rights, but the guardian will have the sole ability to make decisions over the children's medical care, their education, their therapy. And the parent may have the ability to visit, but again, the children will have to live under the care of that guardian. So a guardianship right now, if you're still living with your children, is not the most realistic approach to do in preparing for fear of deportation. This is something that would have to be done if a family member is deported, and then at that point, start that guardianship process. Now, the other approach that we often hear is what's called a power of attorney. This is a written document that you can sign to allow that person to act on your behalf. However, in California, a power of attorney doesn't necessarily transfer the custody of your children over to that person. And the other thing is that in order to get a power of attorney, it's typically done through an attorney that you would have to pay for the services to fill out this document. We do not recommend that you go to a non-attorney to do this. Please go to an attorney that can advise you and can prepare this document. And please do not look up templates on the internet. Again, please go to an attorney. And this is, a document that you would have to pay for the services. So again, the most recommended approach would be to consider that caregiver's authorization affidavit. And again, we'll be sharing templates of that as well. And the other thing to note is that you want to make sure to write down instructions for the care of your children. If they take certain medications, if they have medical conditions, please write down their doctor's information. Have that information handy for your family members in case you are detained. Another good tip is to make sure that your children have valid passports handy in case they do need to travel outside the United States. Please inform your family members and friends, emergency contact, about how they can find you if you are detained by ICE. There is an ICE detainee locator app that you can find. And as Jose mentioned, it's important to know that alien number, your name and date of birth. Have your family members know that so that they can easily locate where you are being detained. And if you do have an immigration attorney, share that information with your family and emergency contact so that if you are detained and you call your family members, they can easily call your attorney and let them know. And lastly, talk to your family members, talk to your kids about what plan you've decided so that they understand what will take place if you are detained. And the last thing, as Jose mentioned, I just wanted to review again the difference between a valid search warrant and an ICE administrative warrant. So again, a search warrant is a judicial document that's given by a court order. It's signed by either a judge, justice of the peace, or a magistrate. And this is the document that would allow them to enter private property to seize, search, or arrest an individual. It must contain the address of the home to be searched, and it must describe the area to be searched. So if an officer does enter your home without a search warrant, it's important to exercise your right and to state that you have not consented them to enter and to search your home. Now, again, the valid arrest warrant also needs to be signed by a judge, justice of the peace, or magistrate. It must state the name of the person to be arrested and describe that person to be arrested. So if you are stopped by ICE officials, the first question you should ask is, am I free to go? If you are free to go, leave the scene. If you're not, and they present you, with the warrant, you want to make sure that you read it clearly and that you understand and see whether it's signed by a judge, whether it states the name of the person they're there to arrest and describe the person that they're arresting. Now, the ICE administrative warrant, as Jose mentioned, is a document issued by a federal agency, the Department of Homeland Security. It is not signed usually by a judge. It's signed by an ICE agent or an immigration judge. You'll see very clearly at the top, Department of Homeland Security. This document does not allow ICE agents to enter your home without your consent. Now, if you allow them to enter your home, then that's another thing. That's why it's important that you do not open the door unless they have a valid search warrant to enter. If they just have the ICE administrative warrant, that does not give them the authority to enter. And if they do enter, it's important, again, to exercise your right and say clearly, I do not consent to you to enter and search my home. And with that, I think we'll pass it over to the next panelist.
Thank you. Thank you very much to the attorney Gloria Martinez. She is recommending to some of the families to get their passports, and I want to take the opportunity to mention that that's my department, the Orange County Clerk Recorder's Office, and people, they can go to anywhere with 3 locations. We have a location in Anaheim, here, the Civic Center in Santa Ana and Laguna Hills. And our department is one of the fastest to issue passport services and vital records. So for the family, the people that is listening to us, don't wait until the last minute, right? Okay, well, now we're gonna go with our next attorney, Jacqueline Dan. Jacqueline?
Okay. Hello, everyone. My name is Jacqueline Dan. I am an attorney with the Orange County Public Defender. Specifically, I'm an immigration support services attorney. So I primarily provide immigration advice to our criminal defense attorneys who work at the Public Defender. So I'm going to talk about one unfortunate situation that some people in the community or some of our loved ones who are immigrants might be unfortunate enough to come in contact with, which is, what if you come in contact with the police? So in this situation, we are not talking about ICE or immigration enforcement. We are specifically talking about police officers and law enforcement who can potentially arrest you and charge you with crimes. So basically, what information can you expect the police to ask you about your immigration status? So the laws in the state of California have become increasingly protective of non-citizens who come in contact with the police. However, it's very important to understand that in Orange County, certain information regarding place of birth, state and country of birth, and citizenship are still routinely collected by the police, by the sheriffs, and our law enforcement agencies. And once they have that information, even if state law says that they cannot share it, you have really no practical control over what happens to this information. I've provided 2 examples here from very recent cases that are newly prosecuted by the district attorney's office. So these are documents from real cases. So first, the California Highway Patrol in a standard driving while intoxicated investigation report, as you'll see, takes down someone's place of birth. And in this situation, the person who was arrested gave them the country of Mexico as their place of birth. So that can definitely be used as evidence against someone to charge them for being in the United States without authorization, and therefore potentially removable from the United States if immigration databases do not show that this person has acquired immigration status. Most arresting agencies will eventually bring people to the Central Orange County Jail in Santa Ana, at which point those arresting agencies have to fill out a booking form. And 2 standard sections of that booking form are state and country of birth and citizenship. Now, it's really important to understand that in all situations with law enforcement, you have the right to remain silent. You have the right to remain silent as to your place of birth. You have the right to remain silent as to your place of citizenship. Okay. Now, practically speaking, it's important to understand how immigration officials find out that someone has been arrested and where in the United States. So anywhere in the United States, when someone is arrested, their fingerprints are electronically captured by the arresting agency. Now, those fingerprints are automatically transferred to an electronic database at the FBI, which is aligned with all of the fingerprint history within all immigration agencies. If there is a match in certain situations, then ICE will transmit a detainer request to that agency that has booked the person into custody and taken the fingerprints. Now, police in the state of California must still release this person on time, even if there is an ICE detainer. But depending on that person's criminal history, and it has to be very specific under state law, they will transfer that person to ICE upon their release. Okay, now it's very important to understand who will have an ICE detainer placed on them through those fingerprints, because it has changed a lot over the years, thanks to both state law and lawsuits that have been filed around this issue. So there are only 2 types of people who will definitely have an ICE detainer placed simply based on a fingerprint match. Now, those are people who are in removal proceedings, meaning a charging document has been filed against them in immigration court. And this unfortunately includes administratively closed proceedings. So those are people who no longer have to go to immigration court anymore because their hearings were basically taken off calendar for humanitarian reasons. The second group of people who will have an ICE detainer are people with removal or deportation orders. So those do come from immigration judges. They can also happen because the person did not appear at their immigration court hearing, but it can also happen at the border, which is very unfortunate. It can happen when someone is stopped or apprehended by immigration officials at the border or a little bit far from the border, but they are sent back to their home country immediately afterwards or to Mexico. So there's another set of people who, oh, if we can go back, sorry. So lastly, there is another set of people who used to always have ICE detainers, but now, thanks to changes in law, they're only at risk of having an ICE detainer placed on them. Having an ICE detainer requires more than just some kind of fingerprint history. So, because people who have fingerprint history with immigration officials could have lawful immigration status or expired immigration status. As part of any immigration status application or benefit, you have to be fingerprinted by the United States government with the exception of very few. Now, in order for those people to have an ICE detainer placed on them, not only does there need to be a fingerprint match, but there also need to be statements or other reliable evidence that the person does not have immigration status or that they are removable. Okay, now will I know if I am arrested and have an ICE detainer? Yes, you are supposed to. The jail is required to give you the ICE detainer upon receiving it. However, it's a little bit unclear what upon receiving means, how soon that they need to do this. Some people are in jail for quite a while before they are ultimately released. And most commonly, the time that the person receives the detainer is upon their release. Now, what are my rights if I am just at risk of having an ICE detainer? Now, if you have some kind of fingerprint history with immigration officials, ICE can request to interview certain people in the jail to get statements or other reliable evidence that would allow them to place that detainer. Okay, however, thanks to state law, which is called the Truth Act in California, that request must be made in writing to each person. Here I have an example of the Sheriff's Department Attachment E, which is their Truth Act interview consent form. Each person in custody, in the Sheriff's Department's custody, has the right to refuse to speak to ICE. So if you notice the fourth box on this form, you have the right to refuse to speak to ICE. Some people do consent to speak to ICE. I personally do not see the benefit of this, but if they do, they have the right to have their attorney present during the interview. Thanks. Okay, now, people with ICE detainers. Does that mean that ICE will definitely detain me from the jail? So basically it depends. If your criminal history keeps you protected under what's called the California Values Act or SB 54 or AB 4, then even if you have an ICE detainer, you must be released on time without the jail contacting ICE at all. Now, in certain situations, ICE will also choose to lift the detainer. Like that can apply to certain situations where, for example, they happen to know based on their experience with this individual that they cannot actually execute the person's deportation, or that for some reason detaining the person is impractical given the status of their immigration case. Now, if the jail does not transfer someone to ICE because they're protected under the California Values Act or SB 54 from getting transferred, does that person have to worry anymore about immigration enforcement? Well, it's very important to know that ICE will eventually follow up on all fingerprint match notifications that they receive from when they received a database match from that person's arrest. Okay, so basically we will see people within 6 months to a year, sometimes a little bit more than a year, get detained by ICE outside of their home very early in the hours of the morning as they're leaving their home on their way to the vehicle, or it's going to be a vehicle stop by ICE shortly thereafter. Okay, now, how will I know if the jail will transfer me to ICE? So for people in local custody, so in sheriff's custody, in the custody of our city jails, the jail must tell you in writing if they intend to transfer you to ICE. Okay, so you also have the right to ask that your attorney be notified of this transfer, and you have the right to ask that any person be notified as well that you are going to be transferred to ICE. So I have two examples here of law enforcement agencies in Orange County making the notifications to people in their custody that they will or will not be transferred to ICE. So on the left is from the Anaheim Police Department. So they have a stamp on each ICE detainer. And in this one, it said, it explains that it was not honored by the Anaheim Police Department. So they're telling the person in their custody at the Anaheim City Jail that they're not transferring this person to ICE. Now on the right is the Orange County Sheriff's Department's form, which is longer. So you'll notice that there are several boxes. There is a very high burden on each person in custody to provide a lot of detailed information about the attorney they want notified and the loved one that they want notified. And it is unfortunately really sad, especially in our office at the public defender. We appoint and assign attorneys at different stages of a criminal case. So often someone in custody will not know the name and mailing address of their criminal defense attorney. But this can also be an immigration attorney, but for this notification to happen, they have to have this information ready at the time that they are being transferred. In terms of notifying certain loved ones, it is very unfortunate when you have people in custody who are, for example, homeless, who are transient or unhoused or housing unstable, and their loved ones are similarly in a similar situation. There might not be stable contact information for the person that they want notified, or the person is mentally ill, and they are not in regular contact with their family or unable to provide this information, which is really unfortunate. So for those of you who have contact with people who are in custody, it is important to try to be as supportive as possible and aware of what kind of information they need to have with them, in case they need to notify someone that they are getting transferred to ICE. Okay, so now it's important to understand, so just at what point in any of this do you have the right to a court-appointed attorney? Unfortunately, it could be pretty far into any of this. So certain people who are indigent, who are facing criminal charges in superior court, are provided an attorney, but this only happens at your first court hearing. Okay, now it's important to know if you are appointed an attorney to represent you in criminal court, all defense attorneys must advise all non-citizen clients of the immigration consequences of any proposed plea of guilty or no contest. Okay, they must do it in every situation. Now, if the defendant requests, so if the person charged with a crime asks their defense attorney, please help me defend against immigration consequences. I want to preserve my ability to qualify or keep my immigration status, and I want you to help me prevent getting transferred to ICE custody from the jail. So if the defendant asks for that, and it's consistent with defense obligations to the client, it's something that we have to do. Now, the Orange County Public Defender, Alternate Defender, and Associate Defender offices have full-time attorneys on staff who do this work. We occasionally file motions to vacate convictions that are older, that have immigration consequences. That is only if you are very low income, and we have been appointed, though. I actually mostly refer people who are income overqualified to Attorney Hernandez, but it's also important to know that in cases where you're appointed the conflict panel or conflict panel attorney, they do not have access to the immigration attorneys in our office to provide that advice.
Thank you, Attorney Jacqueline Dan, for very useful information. So now we'll answer some questions that we have received. I will read the questions and any of the attorneys are free to answer. Question number 1, how do I find my relative if they have been detained by ICE?
Well, I can start and then we can probably answer a couple more questions. So as several of us already have stated, the key is when the person is processed and detained, they will typically be issued what's called an alien number. The alien number is the fastest way to be able to locate somebody. In council here already suggested that there's the ICE locator website where you can actually go on a website and locate this individual. So we would probably urge you to, if you have the opportunity, typically attorneys like myself, at no cost or maybe at a minimal cost for a consultation, can try to help you find this individual. I know also the consulate for our Mexican citizens, the president of Mexico had created an application, I believe it's called Consul app, and that application, Consul Contigo, that application allows you to provide your matricula consular information, your passport information, and not only do you get to put 1 or 2 emergency contact individuals in that application, but the minute you feel like you're about to be detained or you're close to being detained, there's basically a button, I guess, that you press, and a text message will be sent not only to the consulate that is nearest to your home address, but it will be sent to your contact information, to your emergency contact information. So I would urge anybody who is a Mexican citizen and take advantage of that opportunity and download that app. Maybe we can provide at another moment a picture of that application so we can put it up on the screen. We probably should have done that, and I apologize for that. But again, reaching out to an attorney, reaching out to nonprofit organizations, they all are well-versed in trying to locate individuals.
Well,
Anything
excuse me,
to add?
just to add something. Also, they can contact SIAM, as
Yeah.
I told you, that's the Center for Mexican Assistance. So they can call, and we have the number. I don't know if I have the, and
Okay.
also we are making some adjustment in the application. So that's why this time it's not,
Okay.
I mean,
maybe.
the SIAM it's 520
Okay.
623 7874. That's the SIAM. That's the number 24/7. So they can contact, and also
The one that we see right now.
yes, right. It's there, and it's in the United States and Canada. So in any place they are in the United States, so they can call, and we can, any Mexican consulate can't get in. I mean, they can't contact any Mexican consulate, so that we can able to assist them
So this one is specifically for
with legal
Mexican
assistance.
immigrants.
Yes,
Okay.
right. And it's also related with the application, Consulap Contigo.
Okay.
It's also connect. SIAM, it's connected with the application.
Okay, perfect.
So at the same time, so they can contact immediately, so we know where they are and what they need.
Very good. So we're gonna go to the next question. What will happen if a police department or a public agency violates state law protections?
So that is primarily a civil law question at this point because the violation is of state law. Okay, it's not going to be necessarily criminal law, but basically I know that the UCI Law Immigrant Rights Clinic has done a lot of good work for our community members who have dealt with violations of law with regards to specifically transfers from police or sheriff's custody to ICE custody. So that is one potential resource for the community, but basically it comes down to like contacting the right agency and being connected to the community.
Thank you. The next one, how much time do I have to help a detained family member if they are detained?
I think it really depends on the situation. So every case is going to be different. Unfortunately, if a person has a prior removal or an expedited removal, they can be sent out to outside the United States fairly quickly. So it's important to kind of get a consultation with an immigration attorney now to kind of do any checks, maybe do a FOIA on your record to know if you have a prior removal, because that will be something that you'll want to know ahead of time. Now, if somebody doesn't have a prior deportation of removal or an expedited removal, then they do have the right to see an immigration judge and fight their case in immigration court. So again, I think it's important for people to speak to an attorney now. You can do that now to prepare, to get information, and to see what options you may have. Because there may be an option for you to apply for legal status that you may not know.
Thank you, Attorney Gloria. The next questions, will this form be recorded and uploaded anywhere to view later? The answer is yes, it will be on the supervisor's YouTube channel, and we will place a link on the website. So I will repeat, yes, this will be recorded on the supervisor's YouTube channel and will be placed a link on the website. The next question is, what services does the Mexican consulate offer? Can you tell us more about the app? So you just mentioned.
Yes, well, if you contact SIAM, si contactan a SIAM, that's the phone number, 520-623-7874. Los lleva directamente a lo que es la aplicación. So as I said before, it's connected. SIAM is connected with the application. So you call that number, so they contact. with the application.
La clave consul es el número este.
520
para que se
623
conecten las
787.
con
Yes,
las
that's the,
aplicaciones.
yes. If you
Perfecto.
just need to call that number and it's connected the application with the Center of Information.
Muy bien. Y le vamos a recordar a las personas que nos están viendo, escuchando, que pueden ver este el link y pueden obtener toda la información que está apareciendo en nuestro foro. La siguiente, next one, dice, what is the age cut off for doing a document for temporary guardianship? I think that was for you. I don't know.
Oh, 21.
21 is the age
21
in
is the
California.
consensus, yeah.
Okay, 21. Good, thank you. Does California unemployment count for public charge if the person is a DACA recipient?
So if they're a DACA recipient and they're applying for legal status, so for them to renew their DACA, they will not take into account the public charge assessment. So any benefits that they receive based on their legal status won't affect them.
Okay, thank you. Is there a way to return the value of benefits received to not be considered a public charge?
Oh, that's a good question.
I can
Yeah.
possibly answer. Over the years, when we're talking about specifically adjustment of status, we have had individuals where they were able to demonstrate that some of the benefits, especially cash and welfare, were paid back. And so oftentimes you are able to demonstrate that that has been taken back. But I think Gloria made a wonderful presentation about some of the confusion that lies with people and what does count and what doesn't count. So I always tell my personal clients, if it's a health issue, sometimes they're concerned about taking Medi-Cal or anything like that. I'm going to urge you to put your health first and put your kids first before you make that concern, because oftentimes, the public charge issue really doesn't come to fruition. And even under this administration in the first round back in 2017, they tried to impose additional restrictions, if you will. And ultimately, some of that stuff did not come to fruition. So my suggestion to our community is to continue to receive the benefits that you need to make sure that your family is receiving what they should receive. Sometimes attorneys are in a good position to assist you through that process. So I wouldn't worry too much about that.
Thank you. The following question is, has Trump passed any new immigration laws that are in effect?
The answer is no. There have been no laws. Remember that what he has been issuing day in and day out are what considered executive orders. The executive branch does not have the power to enact any laws. In fact, Congress had, I believe this today or tomorrow might be the first day that they're actually going into Congress. So no, there have been no laws passed.
Perfect. Thank you. Thank you. I have one question in Spanish. ¿Puede una persona que tiene residencia permanente viajar a México en este momento?
Yes, the question is if somebody is a resident, if they'll be able to travel outside the United States. And yes, if you're a permanent resident, you do have the ability to travel outside the United States. However, we don't recommend that you stay outside the United States for more than 6 months. And if you have any recent criminal convictions, please see an immigration attorney before you travel.
I would actually add a couple more things. I agree, with Gloria wholeheartedly, but I would urge that not only recent, but we have had individuals that have had convictions over the years that are not so recent, 20, 25 years ago, that may make them inadmissible or deportable from the United States. So if you have, a situation where that you might have had something like you were cited for a petty theft at a Target, where you did not get arrested, but you were cited and you eventually went to court and you in fact pled guilty, that is a crime of moral turpitude. That could cause you some problems if you're a lawful permanent resident. So my advice would be, if you plan to travel, even if you're a resident, okay, and you have had some contact with law enforcement, even if it's what you consider a citation. Oftentimes I get individuals come and see me, I ask them if they've ever been arrested. They're like, oh no, just a ticket. For what? DUI. And that DUI turned out to be controlled substance DUI, okay? So we need to be better understanding of our own personal situation. And I think that the consensus here by all of us attorneys here involved is, please, if you're undocumented and you have some issues, go get a consultation, because it is not, this panel here today is not replacing a consultation for each individual. I think it is imperative for all of us to make sure that we understand where we stand.
Thank you. The next one, I have the next one. Hello, my name is Trixie. I have a question. I have 2 kids with autism. Me and my husband have DACA. What should I do if this happens? I don't know if I understand the question. Do you guys
I
understand?
think
I
it
think I
may
do.
be with
Oh.
caregiver, so how to care for the children.
Should be detained.
Should they be detained? Yeah, so I think going back to figuring out the best approach, you know, talking to a trusted family member or friend that can do that caregiver affidavit in case they are detained or deported. So somebody that can sign that document and be able to make decisions for those children, but also take detailed notes about their medical condition, what medications, who their doctor is, so that caregiver has that information handy.
And I'm going to assume that the person asking the question, those kids are US citizens. And remember, when we were talking about getting a plan together, as Gloria suggested, and I wholeheartedly agree with it, is getting those documents regarding autism together. Put them together in a packet where you also have their birth certificates. I think that the advice that Gloria gave is invaluable. With respect to the caregiver authorization affidavit, it's going to be key for you to be able to get that assistance, right? And if you have those documents, you're going to be able to give the person who's going to represent you a better opportunity, not only to get you out on bond, but to also put together a good defense for an application that is commonly referred to as cancellation of removal.
Perfect. Thank you. The next one, what actions should social workers take when working with undocumented clients to ensure they receive appropriate support and services? What actions should social workers take when working with undocumented clients to ensure they receive appropriate support and services?
Okay, so maybe I can start a
Kelly?
little bit. So especially in this time, so we do have a social work team at the Orange County Public Defender. And one of the issues that we're coming up with a lot is when we place our undocumented clients in treatment programs or residential programs, is making sure that those programs also understand their rights when it comes to ICE and the requirement that ICE have a warrant before they're given any kind of access to those locations and information about the people who are within those programs. I think it's very similar to making sure that schools and healthcare facilities also understand protections that apply, because so many people who are undocumented right now are afraid to go to court, are afraid to seek help, afraid to go to school, afraid to get medical care. And one of those things that they're also going to be afraid of as well sometimes is a residential program, like going into a program and residing there where they really need treatment, but they're afraid of the risk of immigration enforcement. And I think also making sure that social workers are aware of, most social workers are becoming very well versed in which programs and benefits can be accessed by non-citizens. But the Office of Immigrant and Refugee Affairs within the County of Orange also has a social worker who works within SSA to help social workers navigate resources within the county and informal resources that are within the county as well.
Thank you. The next one is a juvenile criminal case. What will be the process for a juvenile who is arrested and identified as undocumented?
So for a juvenile who is arrested, okay, so first it's important to understand that the county does make distinctions for juveniles who are under 18 and then people who are under 21 who might be going through the juvenile justice system because of their age. So Orange County Probation, which has the control over juvenile hall or the jail for juveniles, used to transfer more juveniles to ICE than some counties transferred adults. They stopped that practice. However, their officers do have different policies with regards to people between the ages of 18 and 21 who are supervised by their probation officers but have juvenile cases. And it's really important for people to understand that certain juvenile offenses committed age 16 or over that are considered serious will exempt someone from Values Act protections for life. So it is very important to get a good criminal defense in juvenile court. And there are issues within juvenile court too that can affect immigration cases.
Very good, thank you. The next question is in Spanish. Si me para ICE, ¿es forzoso que yo muestre alguna identificación? If I get stopped by ICE, do I need to show any type of ID?
So typically, ICE does not have the authority to make a traffic stop, right? They're usually done within 100 miles of the border. But if they do in fact stop you, other than providing your name, you will not be providing any other kind of information.
And I'll just add that one thing that we've been recommending our clients is to not present any foreign identification. Because once you do present that foreign identification, a matricula or passport as a form of ID, then you're letting ICE know that you are undocumented. So, you know, preferably not to carry those foreign
Documents, yeah.
identifications,
Yeah.
and definitely don't carry any false identifications.
Right. Mhm.
Okay,
Or even don't say any false information
Right.
also.
yeah.
So it's better to keep silence. So
Yeah.
I have a question. Well, about the Lake and Riley affects permanent residents. I mean, that commit misdemeanor.
I don't believe it affects permanent residents. It's
Mhm.
only undocumented immigrants.
Just
Yes.
For now.
Okay.
But undocumented
Okay.
can include people with temporary protected status, DACA,
DACA.
and things like that. Yeah,
Okay.
it's very specific, so.
You recently.
Okay.
All right. Well, we have 5 more minutes, okay, for the questions and answer. This one, what if ICE attempts to detain you and they do not have a warrant? So you assert your rights to them, but they still forcibly detain you. What can be done in that situation?
If you're encountering ICE at any point in time, I mean, I'm assuming that this is done out in public. Because again, if they're coming to your home, they're coming to your place of employment, you're not opening any doors, you're not giving them any kind of access. The reality is, I think one of my colleagues here mentioned that they do show up in wee hours of the morning and try to make this encounter. And oftentimes, at least in my 24 years of practice, I've had everything from, you know, I'm looking for somebody else, and that's the script that they provide, and they get close to you and they show you a picture that's not even involving you, right? And they're saying, we're looking for this person. Do you have any idea where they're at? Once they engage you, then they oftentimes they say, you know, what's your situation? What's your status? Obviously, if you assert immediately that you're not, you know, not going to answer any questions, and they believe that you are a person that is undocumented, they're going to take you and process you. I mean, we have had stories. I had a story, and I've heard a story from a colleague where an individual came to detain a family, and it was the mother and 2 daughters who were actually U.S. citizens, but they chose to speak Spanish the whole time. Okay, and ultimately, it was the mother who was detained, and both of the kids. One was 16, I believe. The other one was about 10 years old, and they were all taken into custody. At some point or another, the mother spoke up and said, "Hey, you know what are you going to do about my children, because they're born here in the U.S.?" You know, ultimately those kids were released, you know, and they were released in a very awkward way because they knew they had screwed up, right? So, you know, personally, I'm a U.S. citizen, but if ICE were to ever speak to me, I'm not speaking English. I'm just not, I'm going to make them have a day.
Okay.
Okay.
If a person is detained, so can he or she put a bail before they are prosecuted or in prison, or how to proceed in that case?
Sure. You want me to answer that? I can answer that. So it's actually, in my opinion, going to depend on the number of people that they're enforcing, right? So we've all understand that oftentimes when they're doing a lot of, you know, processing of individuals, and the individuals do not have a criminal history, oftentimes they will release them on their own recognizance. Oftentimes they will allow them to go ahead and get an ankle monitor or GPS. And if rare is the time wherein if an individual has a criminal history, I especially believe that under this administration, they're probably just not going to give him any bond. They'll issue a zero bond and will allow the immigration judge to, decide whether they're bond eligible or not. So while there's three different ways that things can go, I think under this administration, the chances are that individuals were going to have to assert their right to see a judge in order to secure a bond. And it is not going to be a bond that an immigration officer is going to extend. Not necessarily because they don't want to. I just think that the policy is going to be going that way.
Okay. Thank
Well,
you.
thank you very much. Thanks to our panel of attorneys for their presentations and responding. We have a few more questions, but we don't have much time. So for now, I will pass to Supervisor Sarmiento. He has additional remarks. I don't know if he's ready. If he's not ready, we can maybe, oh, he is ready? Go ahead, Supervisor.
Martin, I'm always ready. I think,
Yes.
we all have to be ready. So listen, let me just begin by saying muchas gracias a todos ustedes que ofrecieron información, que ofrecieron preguntas esta noche. Thank you, everybody, for participating and for offering questions that were really, really excellent. And the advice in response to those were equally excellent. I want to tell you that almost 300 people are linked in tonight to this forum. And my hope is that this is one in a series that we'll be able to go ahead and provide. And we're going to archive this. It'll be on our website. So those who weren't able to see it tonight or participate will be able to go ahead and download it. I do want to say there were some questions that were asked. And before I say that, it just bears repeating. This isn't legal advice that we're offering. I'm a lawyer myself. We can't do that. But what we can do is provide information and accurate information. And that really was the goal of tonight, is just to provide you with information. I think everybody to a person, I think, will recommend that you go consult with a specialist. And if you've heard some experts tonight that were able to answer some very specific questions and give you guidance on many things. But one thing I did, hear, and I want to repeat this question from one of our members of the public, was that what happens if the police, law enforcement, or a public agency violates the law? What recourse or remedy do I have? Well, contact the California Attorney General's office. I know that they've been very strong. Attorney General Bonta has made sure that he's been in contact with our office to make sure that if we get notice of any sort of violation of the law from anybody, any public agency, we should notify his office. So please keep that in mind. I also want to recognize somebody who joined us a little late, but is with us and has been a partner with us as well. Council Member Carlos Leon from the city of Anaheim. Thank you, Carlos, for joining us. And, I also just want to thank our staff that helped put this together. And it's been, a week, quite a bit of work for them. They're not used to putting things on like this virtually, because we normally do our forums and our town halls in person. But we wanted to make sure that people felt safe and their anonymity and their privacy was respected. And I think this was probably the best way to do it. To our panelists, to the Consulate General of Mexico, Audrey Rivera Gómez, muchas gracias, señora cónsul, por participar y estar aquí y siempre ser alguien con quien podemos contar. To our lawyers, Jose Alfredo Hernandez, Gloria, and Jacqueline, thank you so much for the valuable information. All of you are doing this volunteering and giving of your time because you care about our community. So I can't thank you enough on behalf of all our residents that are logged in tonight. I also want to, especially thank Jacqueline because she's part of our county family. She's with the Orange County Public Defender's Office, and we feel really strongly that we have some of the best public defenders in the state and in the country. So, thank you, Jacqueline, for making yourself available tonight. And I think she had mentioned that we also have an Office of Immigrant and Refugee Affairs. So those of you who may have some questions as far as resources that the county has available, please, contact that office. And I do want to say that, especially our partners at the school districts within District 2, Santa Ana Unified, Garden Grove Unified, Tustin Unified, Anaheim Unified, and Orange Unified. All of you school board members and superintendents and faculty and staff, thank you so much for helping us, because we know how troubled you are about your families and students living through this moment. Finally, I'll just leave you with this. We're producing a lot of these cards that people can carry, and it's just a brief description of what your rights are, some of what you heard tonight. It talks about some responses when you're at work, when you're at school, when you're receiving health care, and then on the other side, we're going to have some information as far as resources, so you can have in your back pocket if something happens, or if you know of somebody who needs the support. We're going to produce these and try to make these available throughout the community, both in English, Spanish, and Vietnamese. So with that, just be calm, everybody. Know that you are surrounded by people who care about you, respect you. Don't listen to false, misleading information. There's a lot of it out there. Unfortunately, it happens in moments of crisis. People just tend to say a lot of things that are just not true, and realize that we have an ICE office and station not too far from here in Santa Ana. So you're going to see cars rolling around. That doesn't mean that there's raids or anything going on. It just means that we live in an urban area, and this is the urban part of the county. So you will see that, but don't believe everything you read on social media. Unfortunately, our friends in the media, I hope, will just try to calm everybody's nerves throughout this time, and that's what tonight was all about. So I just feel very grateful for all of you who joined us tonight, and the panelists who gave some incredible information. Stay safe, everybody. God bless. Que Dios los bendiga. We'll be fine. Everybody just stay together, and we're resilient. Buenas noches. Good night, everybody.